Welcome in, welcome in, welcome in. Let me just pull some information up here. I want to thank a couple people, but I want to thank them without necessarily saying who they are in case they don't want me to say who they are. But I've been getting some emails, and I want to let you guys know that I really appreciate the emails. I appreciate it when you guys send me emails. If I'm doing something wrong, I want to be told about it. If there's something that I need to see, I need to know about it. You know what I mean? I'm not like some people. You know what I'm saying? So welcome in, everybody. Sassy, thank you for being here. Simba, Evelyn, Dad, what up? Truth be told. Jethro, what up? Nathan, what up? Disabled. Outcast, early and often, baby, early and often. Here's the deal. Brian's in the chat. What's going on? Jenny, what up? We got Nathan in the house. So, we're just gonna... We all saw, right? We all heard the last court hearing. But I think it's important that we dissect these statements. So that's what we're going to do. We're going to dissect this statement by Shannon Walker. Because, I listened to this and okay, let's be clear. It's not a statement by Shannon Walker, right? It's a statement by Matt and Shannon Walker. You could hear Matt's cuckery in the statement. So I actually had, where is it? I had somebody reach out to me, one of my awesome subscribers, broke down the whole video for me, cut out things that I needed to cut out, things that I thought would be important, and I think we're going to be able to just go right to this clip.
Thank you for the opportunity to speak. While I understand that specific sentencing details, including any prison time and probation conditions, will be determined at a later stage, I feel compelled to make my position clear now, as these conditions are critical to my support of a proposed plea. I appreciate that Mr. Myers appears prepared to plead guilty to the many crimes he has committed against me. In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained and calculated pattern.
Sorry, Sassy. If it's possible, can we get a little lie meter going on here? I already feel like there's going to be some lies. What up, Raya Hoot? What up, Paul? Hello, Dimes. News Now, Victoria. Where's this full hearing? It's on my page. The full hearing is titled "Enter New Character, Presiding Judge Danielle B. Liwski." So if you want to, here's what we'll do. If you don't want to listen to me, you can go watch it there. I think it's like 33 minutes in, something like that. But if we could get a lie meter going on this, because I feel like I just heard a lie already. I heard one of the many crimes committed against her.
Stop the many crimes. I appreciate that Mr. Myers appears prepared to plead guilty to the many crimes he has committed against me. In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained and calculated stalking and harassment that cause serious harm. These are not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging. However, while I do support this plea agreement, I have serious reservations. Mr. Myers has shown time and again impulsive technology to the many crimes he has committed. I appreciate that Mr. Myers appears prepared to plead guilty to the many crimes he has committed.
Seeing this mic, got to make sure it's on before I start talking. Sassy, the way I'll give it to you is I'll give you the timestamp off of the video that we're watching. So 150:59, one of the many crimes.
Appears prepared to plead guilty to the many crimes he has committed against you. In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained.
So did Mr. Myers commit many crimes? Did that happen? That's what they're alleging, right? They're alleging many crimes have been committed.
Calculated pattern stop his conduct is not protected speech he has committed against you. In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained and calculated pattern of stalking and harassment that caused serious harm. These are not
stalking and harassment that cause serious harm. Okay, but it's important to point out, did Mr. Myers ever encourage somebody to reach out and harass? Because I heard the exact opposite words out of Mr. Myers' mouth: don't harass, right? I heard, I can't remember what I heard, but it wasn't, I never heard the words harass. I never heard that. I heard liar. I heard all kinds of stuff like that about the Walkers, that they're liars and manipulative people. But maybe I'm missing something here. Let's just, maybe I'm...
isolated on calculated pattern of stalking and harassment, not protected speech against you. In doing so, he is acknowledging that his conduct is not protected speech. It was
So she thinks that he's acknowledging that it wasn't protected? Not so fast.
sustained and calculated pattern of stalking and harassment that caused serious harm.
15109. 15109. 15109. I don't think there's any pattern of stalking. I think that's a lie.
It was a sustained and calculated pattern of stalking and harassment that caused serious harm.
What was the serious harm?
These are not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging.
Profoundly damaging. How specifically?
While I do support this plea agreement, I have serious reservations.
She does support the plea agreement. While she does support the plea agreement, how can she support the plea agreement? If she believes what she just said, how can she support the plea agreement?
Mr. Myers has shown time and again that he is unwilling to follow court orders. Based on his behavior, I do not believe that he is capable of complying with probation without strict and ongoing oversight, along with serious consequences if those terms are violated. Any plea Mr. Myers enters should ultimately be accompanied by a period of incarceration, which I understand will be determined by Judge Metcalf, as well as
Shannon thinks that he should be in jail for longer. Shannon thinks prison is appropriate. Shannon believes that prison is appropriate for somebody that reached out for a legitimate purpose, had legitimate questions, and then after the legitimate purpose, the original legitimate purpose of his contact, she goes off the rails and she starts lying and going into court and committing perjury And we're just supposed to, this is stuff that's, we're just supposed to let this all go. This is supposed to be permitted. This is supposed to be something that, just deal with it because I'm a special government, where is it? I'm a special government employee that doesn't, that none of this is just filler. I do solemnly swear or affirm I will support the Constitution of the United States and the Constitution and the laws of the state of Arizona. I will bear true faith and allegiance to the same and defend them against all enemies, foreign and domestic, and I will faithfully and impartially discharge the duties of the office of whatever according to the best of my ability, so help me God, or so I do affirm. Signature of officer, that's where Shannon's Walker name, that's where her name would be, or that's where Matt Walker's name would be. Maybe not on the University of Arizona one for Matt Walker, but certainly for Shannon. Certainly for Shannon. But she gets...
Along with serious consequences if those terms are violated. Any case or picture.
What are the consequences for you violating your oath of office? Are there any consequences? Or you can just do that with impunity, right? You can just do whatever the fuck. That's what these people are on. That's what these people are into. They can just do whatever they want. And 99.9% of people would just fold under this pressure. And how could you not? How could you, realistically, look at this. How could you not fold under that pressure? Let's say for the sake of argument, that Lane was going to take this plea agreement. Do you blame him? I mean, seriously, do you blame him? He's looking at 40 years for a voicemail and actions from other people. Not him, but other people.
Should ultimately be accompanied by a period of incarceration, which I understand will be determined by the Metcalf, as well as strong.
So she wants a term of incarceration more than he's already served, because he posted some YouTube videos that weren't about her, that weren't for her or directed to her. They were videos about the lies that you told. Shannon thinks that she can just go into court. She can just go into court and she can just lie.
Okay, this is case C 2024-6055. The plaintiff is Shannon Walker and the defendant is Lane Myers. Ms. Walker, this is a time and place set to hear an injunction against harassment. Ms. Walker, could you please stand and raise your right hand? My clerk's going to swear you in.
Do you solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes. So, thank you.
So that's a secret hearing, right? This is a secret court hearing that wasn't discovered until many months after everything. But it's okay for Shannon to go in and to lie. To tell how many lies? In the span of 15 minutes? In the span of 15 minutes, she's able to belt out how many lies? Do we remember?
Forcible probation conditions, which is conditions that are specifically designed to protect me, my family, and the community. These measures are necessary not only to reflect this probation conditions, understand will be determined by Judge Metcalf, as well as strong enforceable probation conditions, which is conditions that are specifically designed to protect me, my family, and the community. These measures are necessary not only to reflect the seriousness of Mr. Myers' crimes, but to ensure that I and those close to me can.
The seriousness of the crimes. I mean, I just can't wrap my head around this. The seriousness of the crimes. So Lane makes a bunch of YouTube videos. These are crimes. You know, and what they want is for all this to be a crime. These are all crimes. In Arizona, they want to make all of these crimes against all of these people. This bitch, these bitches, that son of a bitch, that cunt. All these crimes, huh?
Or is safety. When the court considers
Safety from Lane's scary YouTube videos where he doesn't advocate for violence ever. I've never heard him advocate for violence. I've never heard him say that threatening or harassing is appropriate. But we're still going to just try to railroad him.
sentencing, I will be prepared to request conditions that provide meaningful protection. In the meantime, I respectfully ask the court to take this into account as the case proceeds. Thank you. Thank you very much.
Okay. Thank you. 152.13. She says thank you. That's the statement.
George, are you still ready to go through with the plea? And so I just need the signed copy and I can leave.
Okay, I don't even understand. Is it important, do you think, that she...
If you're ready.
Is it important, do you think, that she tells what the actual crime is? What happened, Shannon? So is that time right? Accepts plea, Shannon, victim. Let's see here.
Your Honor, thank you for the opportunity to speak. While I understand that the specific sentencing details, including any prison time and probation conditions, will be determined at a later stage, I feel compelled to make my position now, as these conditions are critical to my sentence and the proposed plea. I appreciate that Mr. Myers appears prepared to plead guilty to two of the many crimes he has committed against me. In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained and calculated pattern of stalking and harassment that caused serious harm. These are not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging. However, while I do support this plea agreement, I have serious and profound harm. These are not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging.
How are they damaging? And how are they different than any other... How are they different than any of the context to Stacey Jane? Why are you so special, Shannon? That's the thing I don't understand. What makes Shannon think that she's so special?
However, while I do support this plea agreement, I have serious reservations. Mr. Myers has shown time and again that he is unwilling to follow.
How can she support it?
Based on his behavior, I do not believe that he's capable of complying with probation without strict and ongoing oversight, along with serious consequences if those terms are violated. Any plea Mr. Myers enters should ultimately be accompanied by a period of incarceration, which I understand will be determined by the path, as well as strong enforceable probation conditions that are specifically designed to
My camera's
protect
frozen.
me, my family, and the community. These measures are necessary not only to reflect the seriousness of Mr. Myers' crimes, but to ensure that I and those close to me can report his safety. When the court considers sentencing, I will be prepared to request conditions that provide meaningful protection. In the meantime, I respectfully ask the court to take this into account as the case proceeds. Thank you. Thank you very much.
That statement's total garbage. Matt could have done better, I feel. Let's do this. let's go through the factual basis, right? Let's go through the factual basis, and then we'll return to Dirty Rotten Lion Shannon and see if what she said comports with the reality of the factual basis. So here we go.
Basis is that on June 4th, I arrested for booing at the city council meeting. Matthew Walker started questioning me. I began investigating him. I determined that his wife was a government employee for the state of Arizona who worked at the law school and worked with Matt Walker on special projects between the two entities. At that point, I then made a YouTube video I made a phone call to Ms. Walker, and I advised her that her husband was violating the law, and she had an oath, and I called him a crooked-ass prosecutor. And so then, in retaliation, she went and had her and Stacey Jane had my wife fired from her job. So then, at that point, I made a video explaining what happened about her role in that, and then I made a video which showed her government information on a government website. And at that point, she went and retaliated by coming to this court and getting an ex parte injunction against harassment by lying to Judge Walton.
Okay, well the harassment is after.
No, she got an injunction for harassment.
Okay.
By lying to Judge Walton, Judge Weiland, and then the next day she came dismiss that injunction for harassment unlawfully issued again by Judge Walton after saying if you dismiss it, you're not eligible to get another one. She was then granted another one without testifying to any facts.
And just to pause here, we want to keep in mind that the original case, the original injunction, C20246055, in front of Weiland, is right here on October 9th. I think I'm getting the judges straight. Correct me if I'm wrong, if somebody knows. And then the very next day, they go back, right? They go back. Let's see, we can just go through it. So here's the hearings that they so they were trying to hide these hearings and these hearings. They hid them for, so when did I didn't place this order until January 21st. That's when we found out about it. That's when Lane found out about it. We ordered it that day. 2 time frames. So 6055, she gets the injunction, it's upheld, right? And then she comes back the next day and says, oh, whoops, you guys didn't take the videos away like I wanted. So she went a little judge shopping, and then they throw this out, and then they use the same facts, which they cannot do. Okay. All right, Shannon, but you've got integrity. Yeah, Shannon, you're not a dirty liar, are you? Okay.
Their acts contained in the petition. I was unaware of that until I was served the injunction, and then once I was served the injunction, I made a YouTube video showing a publicly available public court document which contained public information about a government employee. At that point, I then had a hearing with Judge Griffin in which he said all my videos that were previously posted are allowed to remain posted because it's my First Amendment right to have those videos up. He would not be ordering them taken down, so I left those videos up and I moved on from November to January when a judge in this court made me aware of the hearing that supposedly disappeared on October 9th. When I became aware of that hearing, I paid Tracy Robinson $35 for the record from the court reporters. I then posted that hearing on
Warren.
letting the whole world know how Shannon Walker committed perjury 33 times in 9 minutes with Judge Wine.
Everybody say hi to Warren. Let's take a pause just for a second, see what Warren has to say. And Lane Myers got his girlfriend, who is a federal employee, got her to file a protective order because Chris Ruff posted her picture on his channel. Wow, if that's not a hypocrite, I don't know what is. Do you have evidence that Lane Myers got his girlfriend? That you've got some evidence? I'll wait, Warren. Sassy, that's a great idea. Let me see if I have his stuff somewhere convenient. Bear with me for a second, folks.
Yeah, hi, this is Lee. Please leave a message at the sound of the beep.
At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options. To leave a callback number, press 5.
Warren, I was hoping we could talk about it. Give me a call back, I guess. I guess you didn't want to talk about it anymore. I don't know. Oops.
Went back the next day and somehow issued an injunction based on one alleged act, and then was told that the hearing will be sealed unlawfully. I thought that was newsworthy, so I made a video. I posted that. At that time, I had an injunction which unlawfully restricted my ability to disseminate information about government employees. I knew that it was unlawful. I was appealing it, so I went ahead and made the video anyway. I exercised my First Amendment right to disseminate information about government employees, and that was a 4-part series. I made 4 videos about her lies in court, her Judge Walton's issuance of the injunction, despite her stating in the hearing that if it was dismissed, she would be unable to do it. She did it anyways. I thought that was newsworthy.
Very
I own a
newsworthy.
news media company in the state of Arizona, so I thought my freedom of press would outweigh the injunction. I then posted that, and
Warren just disappears. He comes in there, vomits that comment up. I try to give him a call so we can have a conversation. And where is he? Come on, Warren. Or Lee, or whatever your name is. We can't have a reasonable discussion as men. I mean, that's how you solve your problems. You just yell a little bit and then run away. I don't know. Not a real productive dialogue, though. No, we really can't get anywhere if we can't talk about things, right? But that's how this side works. That's how this side works. They silence the critic, jail the critic. Warren's the same as Shannon. Warren's the same as Matt is the same as Matt Walker. These are authoritarian people that they think that any power the government has is righteous, and anything the government does is righteous, and any act that the government commits against one of its citizens is righteous. Everything that's happening to Lane here is somehow righteous because Shannon, you can't talk this, guys, you cannot talk this way about Shannon Walker. She's a different kind of special. You don't get to criticize Shannon Walker. If you criticize Shannon Walker and you're in the state of Arizona, he's looking at life in prison, effectively. Life in prison for calling out a government parasite's lies. Huh. Okay. All right, Warren.
Then moved on to Lake on February 22nd. On March 7th, they indicted me using the detective's lie to the grand jury, got an indictment, and then I was served that indictment on March 12th. I came to court on March 14th and was arraigned on that charge.
So, Mr. Myers, I heard you say that you made some calls.
You made one call.
A call to Walker. You did four.
Prior to the injunction.
Right, that would be within the September 12th, 2024 to February 22nd.
Yeah, I called them up through a voicemail saying that Matt Walker was a courteous prosecutor.
And then there were 4 videos
True.
that you posted.
Containing the FTR that I paid $35 for from the court reporter.
These videos.
And so
Or
you
audios.
posted some things that sounds like you only engaged in a course of conduct toward Ms. Walker.
Is that true? Did he knowingly engage in a course of conduct against Mrs. Walker, or did he knowingly engage in a course of conduct to expose Shannon Walker? I think that's a more accurate statement.
So you posted some things that sounds like you only engaged in a course of conduct toward Ms.
See, she adds in those next few words, towards Miss Walker. Why?
Sounds like you only engaged in a course of conduct.
Sounds like you knowingly engaged in a course of conduct. True.
Toward Ms. Walker.
Toward Miss Walker? Huh? No. Just because you make a video and it has some facts, some points about a specific person, doesn't mean that it's for that person. Doesn't mean that it's directed at that person.
Sounds like you only engaged in a course of conduct toward Ms. Walker. What I want to know is you also reported to this, which would cause Ms. Walker to reasonably fear for her safety or the safety of the family. So with
There's
regard,
no threats.
so there can be direct threats, which are pretty obvious, and then there can be things that just make you
Oh, there's only true threats.
Mayor, I can supplement a little bit.
No, she said she wasn't saying nothing. She wasn't saying nothing.
Sir, I can reject the plea, because I don't have facts right now.
What up, Tag?
Those are the facts.
Let me
Those are the facts.
hear what the style says.
Your Honor, he engaged in posting Ms. Walker's information regarding her work email, her work address, her work phone number, and then he would put on to.
He didn't engage in posting. He engaged in reposting. I think there's a big difference there. If Mrs. Walker doesn't want her information, her publicly available information, if she doesn't want it to be seen by the public, then she needs to take some actions to make sure that the University of Arizona, if the University of Arizona thinks this is a problem, then they need to take action to protect Mrs. Walker, right? Why? Tell me why. Tell me why you can do this. You can go to Google. I mean, why is it? Here, let's go back to this for a second.
Is used for workers, information regarding her work email, her work address, her work phone number, and then he would put on to his YouTube page, and then he put it up there, and he would encourage his followers to contact left her harassing messages, that also range from things like wanting her to be raped and killed. And so these messages kept coming in. He was made aware of these messages. He's indicated numerous times that he was aware that his followers were leaving these type of messages, and yet he continued to put up her.
Realistically, how does he know, unless they're attaching Lane to these corresponds these messages? How is it that Lane knows anything's being done? Why don't I answer my phone, Chris? Sometimes I answer my phone, sometimes I don't. But Warren knows my number, so he knew it was me calling.
Information during this time and causing those followers to continue that contact with her. So he had initial contacts with her where he left her that message. She went to the law school looking for her, but then he also would use his social media to encourage followers to continue that contact.
Do you understand that all of that would have made her fear for her safety? Then do you have any other reason why she would fear for her safety?
Because she doesn't understand that she's putting an oath under ARS 231.
Taking an oath doesn't mean you have a right to be harassed,
I think, right?
great fear.
It's an allegation other people did, not me.
So, but sir, you're promoting them and
I
encouraging
promote
them.
anybody, not even encouraging. There's no factual basis.
Did Mr. Myers ever encourage somebody to harass? Mr. Myers absolutely reached out and told people to reach out to these government officials to redress grievances. He used the words, "don't harass." So, I mean, what gives, Shannon? They've got a mountain to climb here.
For me, encouraging.
Thank you, Mr. Meyer. At this point, I can't take your plea because I have to have a factual basis, and part of that is that Shannon Walker to reasonably feel for her safety or the safety of her family. And if you can't, and I'm fine with that if you can't do it, so you know.
But I'm just curious if you're asking me to admit to that.
Bear with me for a second. I'm going to see if I have... Well, I thought that I could have just easily pulled up a clip of him telling people to reach out, but I can't.
Because the state even just said that other people know.
And that you were aware and you continue to post for address and information and you continue to encourage people.
They posted their address. So I'm confused because I left the state, I said the state, yep, I never refused to do it, and now they're disputing what I did.
Mr. Essen?
I guess the issue is, Judge, what Mr. Myers did was he posted publicly available or publicly facing information that's on the UOA's website. So obviously he has no control of the third parties. You can't stop him from doing
And
whatever.
I also didn't encourage them, that's why.
And yeah, I mean, again, if I cover a news story, if I were a news organization, and I cover news stories, deal with it all the time, you know, you may wind up getting phone calls and comments and things from third parties who see the news story, but it's not like KMI or TV 13 have control of that. And so they would want to be held liable or charged with, you know, harassing and.
Then I don't have a basis.
No, I agree, and that's part of the First Amendment title.
Yeah.
Yeah.
I mean, you're allowed to use the record, you're allowed to use the grand jury transcript, and if you read the grand jury transcript.
Sure, I won't. First of all, I don't have it in front of me. It gets sealed. I can't even pull it up on Agave.
No, it's sealed.
The rule was that you could use anything on the record.
I can pull it up and all that, but even if I do that, I have to have you agree
That what?
And the facts that are in there are accurate.
And the grand jury testimony.
And you've already told me you don't agree with that.
You're saying, well, what the grand jury says and what Rachel Sabalos just said are two different things.
What I have to have you say to me, Mr. Myers, is that on or about September 12th, 2024, through February 22nd, 2025, you knowingly engaged in a course of conduct. I think I have that, because I think I have emails that you've agreed that you've, or a phone call you've agreed you've made, and multiple postings for videos. So I can take that as a course of conduct. So I've got that part of it, which would cause Shannon Walker to reasonably fear for her safety or the safety of her family. I have to have something.
That's subjective, though.
How is it that Shannon Walker can watch one of these videos and then be scared for her safety? Where's the perjury?
Put the foot.
So this right here, Shannon saw this, and she was...
It's not my cell phone. It is my work line,
It's your work line.
which is
Okay.
listed on the College of Law's website. And in the voicemails, he has said he was going to come see me, made comments about how I need to speak to my spouse about his case, things that are generally
Liar.
just
Didn't happen.
offensive and, not something that I feel like I should be subjected to.
Oh,
And based on these,
not something I should feel subjected to. So Shannon doesn't think she should be subjected to it, and therefore...
Well, our safety or the safety of her, which would cause Shannon Walker to reasonably fear for her safety or the safety.
So let me get this straight. Shannon Walker sees a video. Here's a video that documents her own lies. Her own lies. And because she saw a video that had all of her lies neatly packaged within it, she thinks that it's...
Which would cause Shannon Walker to reasonably fear for her safety or the safety of her family.
How on earth is this video... How on earth does that make Shannon fear for her safety or her family's safety? Did Mr. Myers ever ask anybody to reach out and harass? Did that ever happen? I'll wait. Warren, did that ever happen? No.
I have to have something.
That's subjective, though.
Well, I have to know that you agree that what you did made it reasonable for her to fear for her safety.
So let me get this straight.
What you did made it reasonable for her to fear for her safety.
What he did is he posted this video of Shannon lying. And what they want us to believe is that it was reasonable for Shannon to fear for her safety. It's only reasonable to fear for your safety if you think there's an adverse consequence to your lying, right? Otherwise, what's going on here? Somebody tell me.
safety of her family, and I don't have that right now, and I'm okay not having it. I'm not asking you to give me something you can't say, but if it's reasonable for her to fear, based upon these phone calls and the things that she was getting, that you initiated by putting her information out there, it may have been a public-facing website, but you put it out there in a different way. If you would agree that that reasonably resulted in her having a fear for her safety, then I can move forward to the second one.
Why? Let's just unpack it. Can somebody take me to the time and or the place where he did something that would prompt somebody to reasonably fear for their safety? Where's the link? Shoot me the link. Send me an email. I've gone through all kinds of these videos and I haven't found it. I haven't found it, guys. Has anybody else found it?
Asking me to admit to allegations that are not made against me.
That's exactly right, John. That's what they're trying. The whole case hinges right on that. You're responsible for somebody else's actions. I've never advocated for harassment or violence. I don't want those things. Those things aren't conducive to change in my mind, right? But where's it at? Where is it at? You got to bring the facts. And this is not harassment. This is not stalking.
And I'm just fine if that's how you're doing it.
You're saying that you want me to say that I believe Shannon Walker, it was reasonable for her safety based on my conduct. But the state just offered evidence of other people's conduct saying they would do this or that. I never said I would do this or that, and I never encouraged people to do that.
So, Mr. Myers, so the same thing happens to me again taking a drug plea. It's charged for sale, the plea is for sale, they can admit they possessed it, but they deny that they did it for sale. I cannot accept that plea. It may be a crime to possess a drug, but a plea agreement I have is possession for sale. I have to have both count. I have to have the drug and I have to have the sale. In this case, I have to have the conduct, which I'm comfortable with, and then I have to have, which would cause Walker to reasonably feel for her safety or the safety of the family.
I want to be objective. Okay, I want to be objective because, I don't want to... I want to be objective. We'll just say that. What action? What action? Send me the video. Send me the video. None of this is reasonable.
I have to have the conduct, which I'm comfortable with.
Has the conduct. Okay, you got the conduct. I'm with you on that. You got the conduct. He did make the videos. He did place the phone calls. He did those things.
And then I have to have, which would cause Walker to reasonably feel for her safety or the safety.
Why on earth would any of the things that Lane did, why would it be reasonable for her to fear for her safety? Lane says Shannon's a liar. Reach out and let her know that we think she's a liar. Is that harassment? I'll wait. Is that harassment? No? I'm not getting... Maybe the chat died or something. Everybody still there? Oh, no. Chat's still working. Alright, I don't know. This is a real tough mountain they gotta climb here.
In this case, I have to have the conduct, which I'm comfortable with, and then I have to have, which would cause Walker to reasonably feel for her safety or the safety of the family. I have to have that. So if you can't acknowledge that your conduct would reasonably result in that, I'm okay with that, but it just means I can't take the plea because I have to have both factors.
So my question is where does that stem from? Because the rule says that the court needs to find the facts, not that I need to admit to them.
Well, I need to have a factual basis, and
Right,
I
the
get
state-
that from individuals.
the state could do it.
And then I asked you to agree to it, and you didn't agree to what they said.
Because the rule doesn't say that I'm required to admit anything.
So, sir, I will not take a
So that's a
plea.
personal, that's your personal,
That's the way,
interpretation of.
my view of the law is that the defendant has to enter a factual basis and enter a plea. And they need to do so knowingly, intelligently, and voluntarily.
Is that
So
your
they either
version
have
of
to-
Rule 17?
That's my view of law. I will not take a plea just because the state rattles off a bunch of stuff and have defendants sit there quiet. Every plea I've ever taken on 9 years on the criminal bench included a factual basis that somebody provided and that the defendant agreed to. If you cannot agree, no problem whatsoever. I just won't take the plea, sir. I have to know you agree to the factual basis. If not, I will not accept it.
Listen, I'm glad the judge, I mean, to me, that sounded like integrity, right? To me, that sounded like integrity. Okay, I won't let you plead guilty to something that you don't believe that you did. I think that's my take on her. I don't agree with all of the rulings that she made, but we got to remember that I'm just the guy on YouTube. You know, I've got all kinds of opinions. It doesn't necessarily mean that they're based in law. And Jason, you're right on, bro. The whole thing, like, they would have us believe today that not those people are not being controlled by Lane. Those people, they're somehow able to be objective. But if you agree with Lane, you're automatically not objective and you're under his spell, and you think that whatever he does is okay or whatever.
And you're welcome to try Judge Metcalf. I don't think he'll accept it either, but.
Well, you're saying that, when you said the law, or whatever, that you're saying you need it based on the law. Are you saying based on Rule 17? Because the way I read Rule 17 in the case law is that the judge is required to make that finding based on the record, not on me admitting it.
Yeah, I can look at facts from the record, and then I can look at you and say, do you agree with those facts? And if you agree, that's fine. I will
Well, if
not
you look
take
at the
the
record
plea.
into that, I would be more comfortable than with the state, just like you said, just rattling off some stuff and then saying, do I agree? Because
So
what she
with
rattled off is not what I'm trying to.
With what you did, the course and conduct of the posting of the videos, the phone call, with that, was it reasonable for Ms. Walker to fear for her safety or the safety of her family? Was that
I
reasonable?
don't think that she should have been fearing for her safety.
Okay, then I don't have a factual.
Fuck, man. You'd think I'd be able to handle that. There's a giant light that activates when I start talking, or when the mic's on. Is there anybody in the chat? I want to have a discussion about this. Is there anybody in the chat that actually believes that Shannon Walker should have been in fear for her safety? Anybody? Alan, I don't actually think this is going to end up in a higher court. I think for all of retard Rachel's talk that they are not ready for this trial, it would be a huge error for them to take this to trial. I think that the case is going to be dismissed on the 22nd, the day of trial. That's just what I think. But, you know, shit in one hand and hope in the other, and tell me which one weighs more. You know what I mean? That's just what I think. I don't think they can put Shannon Walker and Matt Walker on the stand and have them be cross-examined by Lane Myers. I don't think they can afford to do that, because they do have to consider the cost, right? They do have to consider the fact that there's already a notice of claim. You know, he's already got these lawsuits teed up, and now they're gonna get on the stand and they're gonna provide him more evidence for his civil case. I don't see it. Now, at the same time, I'm hopeful. I'm hopeful that they're that stupid that Shannon and Matt get on the stand. There would be nothing that would give me greater satisfaction than to see these toxic, poisonous wretches of society be dismantled by Mr. Myers.
So, and which is fine, again, no problem. I am gonna make sure that, Michelle, can I have you?
Your Honor, I have a Donald record because after this, like, we're gonna pull the plea, so
Okay.
we're gonna be done, and we're just gonna go to trial.
Then let me hold on to this for one more minute.
So if he can't agree that him posting those videos caused those people to reach out to her, and that they wouldn't have reached out to her but for him doing that,
That's different, isn't it? That's completely different than the allegation. This is a very let's make a little clip of this. This is important, I think.
Hold on to this for one more
so
minute.
if he can't agree that him posting those videos caused those people to reach out to her, and that they wouldn't have reached out to her but for him doing that, then there's.
I think they reached out based on her lies in court.
So I think we don't have it.
So it sounds like we won't get there, so we're just gonna.
That's why I reached out.
Let's just go ahead and do the Donald, since we're gonna.
Is that why I must have noticed it in the moment. Seriously, though.
I think they reached out based on her lies.
For him doing caused those people to reach out to her, and that they can agree that him posting those videos caused those people to reach out to her, and that.
Is that even... He asked people to reach out to her. I asked people to reach out to her. That's different than asking people to reach out and harass her. You fucking retard, Rachel. These people...
They wouldn't have reached out to her but for him doing that, then there's.
I think they reached out based on her lies in court.
They reached out based on her lies in court. They reached out because of her lies in court. These are the lies.
Little threatening.
Yes. Not only from him, but now his followers are threatening me, contacting me, leaving voicemails. Yes.
So those are three different things, right? Those are three different things. Are they all crimes? Let's listen back.
Yesterday I received one that was particularly egregious. I think I included the text of at least the transcript that are threatening me, contacting me, leaving, but now his followers are threatening me, contacting me, leaving voicemails.
All right, so we got threatening me, contacting me, and leaving voicemails. Those are three different things. Now let's just say, for the sake of argument, that Lane said to do two of them. Reach out to me and leave a voicemail for me. But did he ever say that you should reach out and threaten her? See, this is where this dumb cunt just adds shit in.
Threatening.
Yes. Not only from him, but now his followers are threatening me.
He never encouraged anybody to threaten Shannon Walker. I called Shannon Walker several times. Because she's a liar. And I've got a problem with that. Exactly. Who threatened her, Dale? Who threatened her, and why aren't they being charged? That's the only thing. There's no justice. If somebody can threaten Shannon Walker and Lane Myers is charged for it. That's not justice.
Contacting me, leaving voicemails. Yesterday I received one that was particularly egregious.
Was it from Mr. Myers?
I think I included the text of at least the transcript that my work voicemail system provided.
So she didn't listen to it. She provided the
that my work voicemail system provided.
So her work voicemail system provides a transcription. She doesn't listen to it. She just takes it as the AI did it correctly. So I get transcriptions on my voicemail as well. Do you guys? Have you ever compared those transcriptions to the reality of the voicemail? Oftentimes they're not the same, are they? She didn't even listen to these voicemails, this rotten, crooked government parasite.
So I think we don't have it, so it sounds like we won't get there, so we're just gonna.
That's why I reached out.
Let's just go ahead and do the Donald, since we're gonna pull the plea after today. Please listen to Ms. Stiles. Mr. Myers, I'm gonna ask you some questions when she gives us this information. Go ahead. So, Your Honor.
That's a good question. I can't actually, I'll bring it up here. Looks like the First Amendment. Where is it at? This looks like the First Amendment. All right, so I've got the discovery up. I've got some emails. Dear Shannon, so this is just an email that she got. Dear Shannon, the name of the song is False Allegations. Oh, the false allegations. I'm feeling compelled to write a song about your possible debut on the Freedom Bus. You may not ever actually ride on the bus per se, but you may or may not have the courtesy photo on the side of the beautiful transportation service that will be available to the freedom fighters of 2025. We the people are all tired of your lying and your acting. How exciting, right? What an ode to your amazing legacy in Tucson. A happy Shannon face riding around to educate the world. The picture of your likeness will be fabulous. Rest assured, unless you can find someone more deserving than this drive of shame. Now I have to write a fine tune. The chorus, 3 verses have already been written by you while listening to your disgusting hearing for the injunction. So because you've already proven enough word salad in your own sealed hearings about the Honorable Lane Myers, this song came together very quickly, kind of overnight actually. And because the song is more of a sad saga about your relationship with Lane Myers, we should go straight to the blues genre. Let's do this catchy tune though, so you can dance to it. Lane loves to dance, as you know by his YouTube channel. Or soon he will be dancing around the aisle after the court hearings or the jury trials because you and your beloved husband are graciously going to make him the richest man in Tucson. Okay, this is a long email. It goes on, and I appreciate it. But there's not any threats in the email. But it's in here. So yes, I'm looking at the voicemail. I'm looking at a voicemail transcript. It did have the number. So if threats were made, why didn't they track down the caller? All right, well, let's just, I'll read the transcript. We'll see. I'll read the transcript. We're looking for harassing, threatening, and stalking, I guess. All right, so this was a 59-second email or a voicemail. Quote, Shannon Walker, how do I put it this way? The court of public opinion has decided that you are a bad person, and I think you just need to wrap up and move away. Get out of here. You're not. You're very corrupt. I think you're part of the election and all that other kind of swamp stuff that you guys have been going on down there, and the corruption and your true colors are coming out. And as a citizen of the United States, you are a bad person, and I hope they clean you out. You are a bad person. God, there's something wrong with you, Shannon. What? Okay. Okay.
I'm gonna go through, I'm breaking them up, they'll be consolidated for trial purposes, but I'm breaking them up into segments just as if the on release allegation gets to 2 years extra. So, in this matter, he would have the class 6 felony that would carry, all of this has been mandatory because he does have prior felony convictions, and he's not paying attention, so.
Mr. Myers, make sure you're listening. Okay, the class 6, I'll go.
What is that?
Rachel the retard wants Lane to pay attention. Oh, please listen to me, Lane. Please listen to me.
He does have prior felony convictions, and he's not paying attention, so.
Mr. Myers, make sure you're listening. Okay, the class 6, I'll go.
What is that we're doing right now?
We're getting a Donald record to make sure that you understand.
I thought you said that you were rejecting the plea.
I am, that's why we have to do a Donald record.
Oh, okay.
Go ahead.
So for the class 6 at trial, he's facing the 0.33 years up to 2 years. For class 5 at trial, he's got 5 of the class.
I want everybody to know that this is not threats. These aren't threats. This is just letting them know what could possibly happen. You see me now? I'm back. We're back. Holy shit. We're back. You see me now? I'm back. What the fuck was that about? Holy shit. Nice try. Nice try.
So it has to do with everything. The minimum is to be 4 years in the Department of Corrections, and the maximum would be 43 years. And that's because they can take the first.
That's
class
right.
6
We don't stop.
And sentence you to 2 years on the maximum level. 2, and then there's 5 class 5, so they can each be 2 and a half.
Actually, those class 5s are only class 6s.
Okay,
They
well,
mistaken to label them as a class 6.
that would be a different argument at trial. I'm saying
Well,
the
you
way
said you
it's
gotta make
charged.
the correct record, right? You gotta make it.
So,
It
Mr.
has to be
Myers,
true that.
as it's charged, and as it's charged as a 5.
Oh, I
So,
see what you're
there may be a different argument. There may not even be all those convictions. So I'm just saying the worst case scenario. You can agree with everything as charged. Okay? Okay, so as worst case scenario.
Appreciate everybody's patience.
Face between 4 to 43 years because of the stacking, okay? Worst case, all right? The plea agreement
probation's not available. Even if the judge wanted to give you probation, doesn't matter, the judge doesn't have a choice as charged, okay?
I saw a post here I wanted to comment on here. It was Mountain Mover. Yes, Shannon is a power top.
If, with the plea agreement, probation is available, so that's the first big difference. There's available as charged, it is available under the plea. Under the, as charged, you face between 4 to 43. Under the agreement, you face between 6 months to 2.5 on one, and a third of a year to 2 years on the other. So worst case scenario, running them consecutive, you face between 6 months to 4.5 years. Is something big or weird?
Okay. So I just want to clarify that,
Sure.
the maximum on the plea bargain is more than the minimum on the thing you just calculated.
Correct. So the maximum under the plea agreement, which would mean that the judge had to aggravate it, would be 2.5 years on the class 5 with the consecutive 2 years. So this is what under the law judges have to do. You start at the presumptive. So on the class 5, the lowest is 6 months, the presumptive is 1.5 years, and the highest is 2.5. When a judge looks, and if you look at the statutes under sentencing law, a judge has to give mitigating factors to go down from the presumptive and aggravating factors to go up. So you're right. Under the plea agreement, the 2.5 to 4 years is 4.5 years is more than the minimum you could face if you went to trial. To get to that 4 at trial, if you were convicted of everything, the judge would have to substantially mitigate all of those charges, which is unusual in a case where you have 2 different cases to run both of them all concurrent and together. It's just unusual.
Plea, right?
Yeah, I just want to make sure you understand, because that's what's important.
Even if I agree or not, you said you rejected the plea.
I will reject the plea if you cannot give me a factual basis. If you want to go back and try again, I'm willing to listen. I just need to make sure that...
The delineation between...
I thought he gave a pretty good factual basis.
My factual basis and you accepting it.
So I can only accept a plea if knowingly, intelligently, and voluntarily enter it. I can only accept a plea for that. To knowingly, you've got to know what you face. You got to understand the conditions of the plea. You also have to give me a factual basis about it. I need to know you're pleading guilty to these charges. If you're willing to do that, I will take the plea. If you're not willing to do it, I cannot take the plea.
Can we use the statutory definition of knowingly under ARS 1059?
So, sir, I'm not going to take this plea. I can't make it any more simple than this unless you agree to me that based upon your course and conduct, Ms. Walker was reasonable to fear for her safety or the safety of her family. If you can tell me that based on your course and conduct...
Can anybody, based on Lane's course of conduct, we all know. We all know every word that Lane said. We all know that Lane never asked anybody to reach out and harass anybody. We all know. But let's just be sure. The judge wants Lane to admit to something that he did not do in order to potentially avoid 40 years to life in prison. You have to admit to a crime that you did not commit. And that's justice in America today.
That which would cause Ms. Walker to reasonably fear that based upon your course and conduct, Ms. Walker was reasonable to fear for her safety or the safety of her family. If you can tell me that based on your course and conduct, that which would cause Ms. Walker to reasonably fear, I can take the plea on that count. I still not for the other one, but I need to know that it was reasonable based upon the way this is charged.
Reasonable for her to fear for her safety.
Or the safety of her family. It has or.
You're asking me for my subjective.
I'm asking you to agree that the course and conduct you did would make it reasonable for her to fear for her safety or the safety of her family.
And Judge, I apologize.
That's okay.
I'm really not trying to muck this up, but I think what we're caught up on is what the court's asking, and probably the problem statutorily in this statute, is it requires the defendant to put himself in the place of the victim, and whether or not it's reasonable for her to fear for her safety or the safety of her family is up to her, right? Anybody who actually has that fear feels it's reasonable. I mean, nobody's going to run around and say it's unreasonable.
She's certainly entitled to feel how she feels, but
Right, and I understand what both of you are saying. I just think under the law, there's many times where we use reasonable. Is it reasonably?
RC, that's a good question, and I don't know the answer to it. I actually got an email on that specific question. So I don't know the answer to that question, and I don't know. I will probably be in the minority here, but I think that was the plan the entire time. So that's just what I think. Obviously, only Lane knows, or maybe Resnick knows too, to the extent that Lane is discussing, what was going on right there. But I believe that he just wanted to get the factual record on the record, and that he knew the judge would not accept a plea if he didn't admit to something that he did not do, which he did not do.
That when you do X, Y, Z, this would happen.
And Kevin, all of them, every step of the way, every single time. And the chatter is that he's not, right? But we know.
Is it reasonable that by putting out her address, her phone number, her information, and I understand, Mr. Myers, that they're on a separate public website, but by doing it with regard to the other statements that you made, is it reasonable to believe?
What statements specifically? The statements that you should reach out to public officials and redress grievances, legitimate grievances, perjurous? What do you guys think?
Believe that would then result in her having a fear for her safety or the safety of her family.
So are you already saying that
The jury will have to determine that reasonableness too. So
are you saying that are you just skipping the intentionally or knowingly, or are you saying you find that?
So you have to knowingly engage in a course of conduct. I'm okay finding that because
You have to knowingly engage in conduct that would make her fear for her safety, not just engage in conduct.
Right. So, but what I'm trying to make it so you understand where I'm hung up.
Because I read the ARS, because this legal jargon is the technical nomenclature of the law. The law gives you the definition of knowingly, not Lane Myers or Shannon Walker.
Okay. So, sir, I need to know that you agree that it was reasonable based on your knowing conduct of putting her address, phone number, information out there online, that you knowingly doing that conduct, and by calling her, would reasonably result in her fear for conduct, that you knowingly doing that.
I don't think that knowingly doing something, the connection they're trying to make here, just because you knowingly do something doesn't mean that it's reasonable for somebody to feel harassed. And that's the thing I can't get past. It's unreasonable for her to feel that way unless there's actual threats, right? And the people that are doing the actual threats, those people should be dealt with. Those people should be charged. You shouldn't be able to threaten people, right? But Lane engaged in a course of conduct that encouraged people to reach out to her for legitimate purposes. She just thinks that she is above the legitimacy of the oath that she signed.
That conduct, and by calling her, would reasonably result in her fear for herself or for her family. If you can say that, we can move forward. If you can't, then no problem. We will not go forward.
Judge, would the court accept that we acknowledge that she did fear for her safety and that of her family, and that her fear was reasonable, and that she believed her fear was reasonable? We have no argument about that. It's just that.
Yeah, I agree. Because there's different types of intent there, right? There's the actual intent, which is redress public officials, and then there's the intent that the state is trying to allege that he wasn't asking people to reach out because she's a dirty liar and tells lies. He was telling people to reach out and harass. I don't even know how that even makes sense. How is that productive at all? It's not. It's not productive at all. It's not something that he would engage in, and it's certainly not something that I would engage in myself. I don't want people harassed. I want government to do what it's supposed to do. I want Shannon Walker to... She signed it. You know what I mean? Like, she signed it, but she just gets to do whatever. It's just a rag then, you know? It's just a piece of trash. It's meaningless. I think that's the actual, what we're witnessing here that's the actual issue, is that these parasites think that we're just going to lay down and let them all do this. Cool story.
He can't put himself in her shoes to know what she thought reasonable was, but we'll agree that she did.
I pulled up the Raji just to see how is, for.
That's a jury instruction, just so you know, Mr. Myers.
Yeah, jury instruction.
We always call them Rajis. I just didn't know if you knew that. Sorry.
So, so it says the crime of stalking requires proof that the defendant, one, knowingly or intentionally engaged in a course of conduct that was directed toward another person.
And I'm okay. I feel like I've got that.
And then it says, and that conduct caused the victim to reasonably fear for, and then that's where we get to the safety.
Isn't that up to her to determine though?
Okay, so do you agree with me that you engaged in a course of conduct that was directed at Ms. Walker, that being the phone call and the 4 videos?
The phone call only.
Well, why do you put...
So the phone call was obviously directed at Shannon because he left the voicemail on Shannon's voicemail, right? But to say that all of the videos... To say that all of these videos are directed at the person that they're about is retarded, Rachel. He should be charged with all of these then. Right? All of them. But no. It's only Shannon that's special.
Videos up, that was not directed towards her?
No, the videos weren't directed at Shannon. They were directed at the audience. It's a news story. It's directed at the public. It's saying, hey, we've got these people that are lying. We need you to know about it so we can stop them from doing it in the future. So we can hold them to this oath that's supposed to mean something. This is supposed to mean something. Right? It's supposed to mean something. You can't get hired until you fill out these forms. These are the new hire forms, right? But it's just a piece of paper. It's just a rag. The Constitution's a rag to these people. Their oath is a rag. They only care about power. They only care about power.
Absolutely not. Those are not directed to Shannon Walker. I didn't tell
And
you.
I don't have a course of conduct. One phone call is not enough. So
One phone call is not enough.
Shannon Walker. I didn't tell
and
you.
I don't have a course of conduct. One phone call is not enough. So
The directed at means that I would say, hey Shannon, or I would tag her in social media, or is a cake on 9 story directed at the person in the video?
Absolutely. So I'm going to.
TC, facts. Even the janitor knows. Even the janitor knows that they're subject to public scrutiny. It's just Shannon and Matt that think they're special. We're going to go back to the statement.
Find that there's no factual basis for the plea agreement. I'm going to find that the court has gone through the Donald record and that Mr. Myers is knowingly, intelligently, and voluntarily rejecting the plea because he's unable to provide a factual basis. We're going to affirm the next court date, which I believe is just the trial. Just one of the things. Oh wait, there's a status conference right on July 14th at 9 o'clock.
Are you also allowed to make orders in this case? That to order them, because they've been telling me that I was going to get the pre-trial witnesses for 2 months.
That's a separate order for Judge Metcalf.
Games.
So no on that.
Nope. We're going to let them play the games.
Thank you, everybody. Thank you for everybody's patience.
Oh, well, that's that, huh? Let's get another listen to this. We let Lane get out the facts, the factual basis. The judge tried to reason with Mr. Myers, said, well, you agreed that you engaged in this course of conduct, but the problem is only a moron would be in fear from that.
In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained and calculated pattern of stalking and harassment that caused serious harm. These were not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging. However, while I do support this plea agreement, I have serious reservations. Mr. Myers has shown time and again that he is unwilling to follow court orders. Based on his behavior, I do not believe that he is capable of complying with probation without strict and ongoing oversight, along with serious consequences if those terms are violated. Any plea Mr. Myers enters should ultimately be accompanied by a period of incarceration, which I understand will be determined by Judge Metcalf, as well as strong enforceable probation conditions that are specifically designed to protect me.
What a toxic person. What a poisonous, toxic, parasitic wretch this cunt is. She thinks that Mr. Myers should be in jail for his words, for his videos about Shannon's corruption. Shannon can just go into court She can lie. Sorry about that. Shannon, she can just go in, tell lies. That's okay, guys. If you are the prosecutor's wife, you're allowed to go in and lie on people.
Appeared at the hearing, and of course the defendant is not, because he did not have.
I do not have any knowledge.
All right.
Well, he talks about being a hunter. I only know what he has said to me. We have never even spoken. I've never met him in person. I've never had a direct conversation.
So she only knows what he's said. But he hasn't ever said to threaten. He hasn't ever said to harass. So it doesn't even matter what she's heard. She makes up her own shit.
That you really don't know the defendant. You've never met him personally?
No. One of his claims, I only know what he has said to me. We have never even spoken. I've never met him in person. I've never had a direct conversation with him. I only know the messages that I receive or the videos.
What? Huh? Alright, we have to contrast this, right?
My family and the community, I understand will be determined by the event path, ultimately be accompanied by a period of condition without strict and ongoing behavior. I do not believe that he's saying again that he is unwilling to follow court orders. Based on his behavior, I do not believe that he's capable of complying with probation without strict and ongoing oversight, along with serious consequences if those terms are violated. Any plea Mr. Meyer enters should ultimately be accompanied by a period of incarceration, which I understand will be determined by the event path, as well as strong enforceable probation conditions that are specifically designed to protect me, my family, and the community. These measures.
All right.
No, one of his claims. Oh, yes, absolutely.
Okay. And you've explained that you really don't know the defendant. You've never met him personally?
No, one of his claims, I only know what he has said to me. We have never even spoken. I've never met him in person. I've never had a direct conversation with him. I only know the messages that I receive or the videos. One of his claims is that I think he has assumed, because my work often is with members of the judiciary, apparently he had a significant other who was a federal law clerk and lost her position as a result of, I don't know if it's his videos, but it seems like that was some sort of factor.
She doesn't know, guys.
That I personally am responsible for that. That he often claims I called Judge Zips at district court to have his significant other fired, which did not happen.
Oh, if we had that kind of power.
Right? I know.
So
a lot of things would be a lot easier.
Mm-hmm.
A lot of things would be a lot easier, guys, if we could just do whatever the fuck. A lot of things would be a lot easier if we could just lie on people and get away with it. A lot of things would be a lot easier if we didn't afford people due process and we just threw them in jail because I'm the prosecutor's wife. These people are poison.
Oh, if we had that kind of power.
Right? I know.
So
a lot of things would be a lot easier.
All right. So, power.
To have his significant other fired, which did not happen.
Oh, if we had that kind of power.
Right? I know.
So
a lot of things would be a lot easier.
It doesn't sound like that's a power that she isn't interested in having or wielding, right?
All right. So, do you? I take it you and the defendant don't have any other cases with each other.
No. My husband, on the other hand, he's prosecuting Mr. Myers just for a couple more days.
Are necessary not only to reflect the seriousness of Mr. Myers' crimes, but to ensure that I and those close to me can report his safety. When When the court considers sentencing, I will be prepared to be sweet and report his safety. When the court considers sentencing, I will be prepared
What did she say?
to conditions of Mr. Meyer's crimes, but to ensure that I and those close to me can report his safety.
Can do what in safety?
Sentencing, I will be prepared necessary, not only to reflect the seriousness of Mr. Meyer's crimes, but to ensure that I and those close to me can report his safety. When the court considers
Can report in safety? Is that what she said?
to ensure that I and those close to me can report his safety. When the court considers sentencing, I will be prepared to request conditions that provide meaningful protection. In the meantime, I respectfully ask the court to take this into account as the case proceeds. Thank you. Thank you very much.
What a trash statement. Matt could have done so much better. Matt should have been dedicating all of his time to the responses that he has on that 122 hearing. But he needed to just eke this one out real quick. This trash. This absolute and unmitigated trash.
Your Honor, thank you for the opportunity to speak. While I understand that the specific sentencing details, including any prison time and probation conditions, will be determined by a later stage, I feel compelled to make my position now, as these conditions are critical to my safety proposed plea. I appreciate that Mr. Myers appears prepared to plead guilty to the many crimes he has committed against you. In doing so,
He hasn't committed any crimes against you, Shannon. Alright, guys. That's it. He hasn't committed any crimes against you. You're the worst. You're the absolute worst. You and your husband are the absolute worst. And I think what I'm going to do in the future is just make sure that your names are in all of the titles for the videos for algorithmic purposes. I feel like some of my Shannon Walker videos aren't getting the proper play, so I need to make sure that her name's in all of them, so that when people search Shannon Walker in the future, that it's these videos that they see what kind of person she is, that the world sees what Tucson and the Walkers are doing to an innocent man. That's right, land of enrichment. 33 lies. 33 lies she told right here. Just in this one hearing alone. 33 lies to get this bullshit injunction. And then only to come back the next day with some more bullshit. Some more bullshit. Because they wanted the judge to say no videos.
All right, we are on the record in C20246055. Ma'am, can you state your name for me, please?
Yes, Shannon Walker.
All right, thank you. Could you please stand and raise your right hand to be sworn in? Yes. All right, so it's my understanding you want to modify your injunction against harassment?
Correct. I'd like to have my 2 minor children completely removed from it. I had hoped that maybe they could be listed just as minors, but because I do not believe they can, I do not want their names or their birth dates shared with the defendant.
Okay.
Moron.
Yes, that would be it. That would be great.
Is that it?
Is that it? You
Yes.
got a legitimate purpose, or you want to use the same allegations? It's not really legal.
And modified, and she's going to give you copies for your records, okay?
Thank you very much, Your Honor.
All right, we are back on the record in C20246055.
So they're back on the record at 6055 at the time frames were right up against the end of the day, but that was plenty of time to get in the backside of this. Okay, Shannon.
All right, we are on the record in C20246114.
New
State
case.
your name, please.
Shannon Walker.
Absolutely new case
And
number.
raise your right hand to be sworn in.
She's going to swear to tell the truth again.
Yes.
That's a lie.
Okay. What did you want to do with this one?
So, originally, when I filed my injunction, I have 2 minor children. They were listed on it. I came back today to have that amended, and their names are still listed. And my understanding is that the defendant can ask for those documents. My concern, given his pattern of behavior, is that he will display.
Prophet, you were harassing people today? Is that what was going on? They tried to kidnap you, bro. I might have missed something. More harassment
Their
out of
names and
Tucson,
encourage
huh?
people to. He will incorporate that into his content. So I would like to dismiss that order and start a brand new one.
I would like to voluntarily dismiss the order, and I would like to use the same facts on a new order. Anybody know if that's legal? Can anybody tell me if that's legal?
Oh, with the same allegations.
Correct, exactly.
Judge
That's
is
what I
like,
was advised to do.
Judge is like, I don't think that's how it works, but fuck it. You know what? You're a walker. You're a government parasite just like me. So, government parasites, we got each
The only
other's
way to be
back.
able to protect that. My hope is that the original, the one that has been canceled or will be canceled, will be sealed, so that's not information that is available to anyone.
Well, that's interesting. She's thinking in her head, well, I'm going to have to break the law for these people. But that's okay, because nobody's ever going to hold me accountable.
Because typically when someone files an order of protection and it's granted and then they dismiss it, an order of protection or injunction against harassment, and then they dismiss it, that's it.
That's it. Usually, that's it. But if your last name is Walker,
If there's a way to remove my
if we could just
minor
do it.
children's names from the original, I would be very happy to do that, but I was advised by the people downstairs that that is not possible.
People downstairs giving legal advice to Shannon, letting her know that don't worry, we will break the law for you.
So this is the approach I was advised to do.
Did you already submit it?
I did. I filled out, my understanding is they said that hopefully we could dismiss the original one and then have my new injunction against harassment petition approved. And I understand it's kind of a unique situation, but hopefully.
It's only unique because it's criminal. That's the unique aspect is the fact that they're committing crimes right now, and they've implicated this judge, another prosecutor. So,
And I understand it's kind of a unique situation, but hopefully one that you can see might be warranted based on the pattern of behavior.
Okay. And right now the pattern of behavior is one phone call. That's the pattern of behavior. One single phone call.
All right, so I've indicated that this was refiled due to a mistake in the process.
Well, why'd you do that? Why did you dismiss it due to a mistake in the process? That's not what she said. That's not what she just said. Now the judge is even lying.
Thank you.
Thank you, Your Honor.
So I will grant the injunction against harassment.
Surely we've got to hear some facts about it. Put it on the record. Maybe some evidence as well. None will be attached, though.
The court has jurisdiction over the parties and the subject matter. The plaintiff has appeared today. Defendant is not present. The court finds that multiple acts of harassment have occurred. Defendant is to have no contact with the plaintiff.
But none of those facts are on the record, just for clarity. She's found that there's multiple acts, but zero of them are on the record.
Jurisdiction over the parties and the subject matter. The plaintiff has appeared today. Defendant is not present. The court finds that multiple acts of harassment have occurred. Defendant is to have no contact with the plaintiff. Defendant is not to go to or near the plaintiff's residence. Defendant is not to go to or near the plaintiff's place of employment.
Let me know about that hearing.
So this will need to be served.
In front of Metcalf or...
And it's effective for 1 year from...
pardon me. In front of Metcalf or in front of Liwski again? Do you have the audio from the beginning of your hearing with Liwski Prophet? I missed all that.
Date of service. So the same terms apply. He'll be able to ask for a hearing if he wants to.
Your Honor, one
So, as of right now, the terms are identical to the terms of the prior injunction. They've only, due to a mistake in the process, corruption is the mistake in the process. Public corruption being the mistake. She's going to say this. We're going to try this. We tried it with the last judge and it didn't work. But even though we're exactly where we wanted to be, where the business has been taken care of, the kids got removed, we want to push our luck. Which all this does is this illustrates the real reason for the hearing in the first place. If everything prior is true, if everything she said in here was true, that it's all because of the kids. It's all because of the kids. I don't want Lane to know my kids' names and their birth dates. If that was true, then she would have been happy. Right? Because after all, she's exactly where she was yesterday. She's got the injunction, and now the kids are off of it. Right? But actually, here's the real reason that she came back.
Your Honor, one question. Is the same requirement of not being allowed to post about me on social media included in this?
Well, of course not. because that wasn't included in the first injunction, Shannon. That's another lie. What? So let me get this straight. If it's the same injunction, right? It's the same injunction. Everything would be the same. So if it was in fact included, then it would have been included again. She wouldn't need to make this statement. She's only making this statement because it was specifically excluded from the original injunction, because you can't do it. What a disingenuous lying cunt.
Your Honor, one question. Is the same requirement of not being allowed to post about me on social media included in this?
Well, let's take a look.
Let me double check. Let me go back.
Thank you.
So I've indicated defendant shall have no contact with plaintiff through any form of social media. Defendant is prohibited from posting any messages or content regarding the plaintiff via any social media platform.
Thank you.
Oh. Oh, really? Interesting. Was that on the prior order? These people are so corrupt.
And Your Honor, one final question. When it comes to having the original documents sealed because of the information, is that something I would discuss today, or is that something I would talk to another department about?
Once it's dismissed, I'm not sure if it can be sealed once it's dismissed.
The people I spoke to originally, they thought that might be possible. I just didn't know if I needed to ask you about it while you're here today. But if it's not something that would typically happen here, I can definitely figure it out.
So you should file a motion. You can file a motion.
Okay.
With the court to seal documents and for maybe a protected address.
Okay.
Those might be possibilities.
Okay. Thank you. Thank you.
So I'm looking at pulling up the other one. So I'm going to quash the other one.
Quashing the other one now.
I did indicate on this hearing order that dismissed injunction is ordered sealed.
Oh, wonderful. Thank you.
Hopefully that will.
I appreciate it.
I would follow up to see.
I will.
If
I
that
will.
was done.
All fun and games. All fun and games with these people. Oh, we'll just toss this guy into the garbage. We'll just throw this life away. And we'll just yuck it up the whole time. It's super funny, guys.
Very much.
Oh, thank you very
right.
much. Oh, thank you. Thank you for being corrupt.
Thank you.
Thank you. Thank you for your corruption.
Thank you very much.
Oh, thank you.
All right. Thank you.
Thank you both. I hope you have a good evening.
I'm with you, Mikey. All right. That's that for today. Are we allowed to reach out to the government officials? Are we allowed to do that, or has Tucson and Pima County taken that inalienable right away from us? Reach out to these fucking stupid government officials. Let them know. Let them know how stupid that we think they are, and let them know that we're watching, that we're documenting all of their lies. We're not harassing you. We're pointing out your lies. We're pointing out your public corruption. It's disgusting. It's gross, and we're not just going to stand by and let you do it. Not going to happen. Anybody got any questions? I don't know that I can answer anything, but yeah, Rachel Metcalf isn't biased. Ask Rachel. That's exactly Leslie Sullivan. Thank you very much. That is the name of the game. It's redressing your government. It's constitutionally protected in most states. Alright, I love you guys. I appreciate you being here. Laura Conover, let's get her contact info up here. Actually, I think I got her email over here. Laura Conover. Send this stupid cunt some emails. What the heck? I don't see it. Here, put Washburn's Best in there while I'm looking for this. Give that dumb cunt an email too. Actually, just look in my email. Just look in my email. I've got plenty of emails to Laura. Alright. Give both those dumb cunts an email. Let them know that I specifically asked you guys to reach out to redress your grievances with your government. Use those specific words. I don't, here, just for the sake of clarity, I don't want anybody to threaten anybody, okay? I don't want anybody to harass or threaten anybody. But if you've got a problem with your government lying to you, I think that it's okay to redress your grievances with your government in whatever way you see fit. So, short of true threats. That's where I would like to lay the line down. Let's not threaten these people, but let's have them understand that we're not just going to forget about their corruption. We're not going to just let them get away with their corruption. We plan to redress grievances. That was Walton, I believe. Wyland, was the first one, and I think Walton was the second one. I could be wrong, but I think that I'm correct on that. I believe the next court date is June 19th. I'm not entirely positive about that, though. All right. I think that's all I got for today. Appreciate everybody being here. This is a public service.